Hi, good morning. Let us study about Central Pollution Control Board. We know what are the features of the Central Pollution Control Board because we have already studied in the EVS. Under MOEF, Ministry of Environment and Forest, the Central Pollution Control Board is the national board which have powers to oversight the state board, which have power to control the state board. The CPCB has a central office as well as a network of zonal office located in New Delhi, Calcutta, Shillong, Kanpur, Bangalore and Vadodara. It is established in 1977 under the Water Act. The CPCB has wide range of powers and responsibilities which include recommending the central government on any matter related to the prevention and control of the water and air pollution, and also the improvement of the air quality, planning programs among nations for the prevention, control of water and air pollution. Coordinating the activities of SPCB and resolving dispute among them, providing technical help and supervision of state board, carrying out and sponsoring investigators and research relating to problems of water and air pollution and for their prevention and control and abatement, then prosecuting polluting industries pursuant to the Water Act. They are questioning the pollution creating industries and collecting, compiling and publishing technical data on air and water pollution and the measures recommended for their prevention and control and abatement, then organizing training of staff involved in the environmental problems, and preparing manuals, codes and guidelines relating to industrial emissions and effluents, organizing mass media awareness program on environmental protection, then disseminating information on water and air pollution and the prevention and control and performing such other function as prescribed by the central government. The total number of employees in the CPCB is approximately 500, out of which 100 have technical training. The CPCB has approximately 60 inspectors all over the nation. State Pollution Control Board, SPCB, were established resulting the state legislature's adoption of Water Act during 1974 and then Air Act of 1981. At the state level, SPCBs are attached either to the Environment Department or to the Forest and Wildlife Department. In general, SPCB perform the following function: advising state governments on pollution related issues and planning a widespread state level pollution control, prevention, abatement program. Then implementing and enforcing national standards by making them more stringent if warranted by local conditions. Then granting consent to form and to function under the Air and Water Act and authorize the hazardous waste disposal per rules under the EPA and collecting water cess for the use of the water. Then legal enforcement authority. The compliance monitoring and enforcement is mostly done by SPCB. Few direct enforcement action taken by the CPCB were generally done by the zonal officers. Under the Water Act, the Air Act and EPA, those boards have the authority to issue and withdraw consents to operate, require self-monitoring and broadcasting, conduct sampling, inspection, require corrective action, and propose compliance schedules. The enforcement powers given to these boards include emergency measures of disengaging water or power supply and facility closure and is widely used in some states. With the CPCB approval, SPCB can impose administrative fines for any violation of those rules. This provision of enforcing penalties for illegal storage of hazardous waste is used in Maharashtra. Then the environment tribunals came into existence with the 186th report of India's Law Commission during September 2003, which has exclusive jurisdiction with regard to environmental cases. According to the report, this environment code must be established to reduce the pressure and load on the High Court and the Supreme Court. So, this environmental tribunal has special power related with the environmental cases. All powers of a civil court in the original jurisdiction would be exercised by the environmental tribunal. They would have also applied judicial powers against orders passed by the concerned authorities under the Water Act, Air Act, and EPA and other environment related acts. At the national level, there would be National Environment Tribunal with a corresponding tribunal at the state level also. An area-based environment management program. The area-based approach to environmental regulation has been used in India since 1991 through different CPCB and SPCB programs. For example, the CPCB and concerned SPCB had identified 24 critically polluted or problem area. An action plan for which including compliance monitoring measures have been made and are in various stages of execution. Similarly, urban air action plans have been designed in 17 cities out of 53 identified by the CPCB, where air quality is better than the national ambient standard. It is as per the report of the World Bank 2006. Then these programs have an advantages of focusing regulatory and compliance monitoring efforts to be concerned SPCB. They so far have an average success in India, mostly due to lack of coordinating efforts targeting industry, municipal, mobile, non-point pollution sources. Then sustainability and indicators of sustainable development. Sustainability is defined as the non-declining utility of a representative member of a society for millennia into the future. We already studied what do we mean by sustainable development. And preserving opportunities for future generation is a common sense minimal notion of the intergenerational justice. Brundtland Report, WECD, World Environment Committee Development, 1987. Page number 43, they are stating like this: sustainable development is development that meet the needs of the present generation without compromising the ability to future generation to meet their own needs. So if we are developing now, that meets needs of the present generation, but it should not compromise the needs of the future generation, that we have already understood. And concept of sustainable development are utility of consumption is non-declining through time. The resources are managed so as to maintain production opportunities for the future. Natural capital stock is non-declining through time, and the sources are managed so as to maintain sustainable yield of resource services. The minimum conditions for ecosystem resilience is satisfied through time. Then consumption approach of the environmental sustainability, where consumption needs to be optimized over time and space. Consensus building and institutional development are considered imperative for sustainable development. Then Indian Environmental Laws, 1986. Environment Protection Act was passed by Indian Parliament on 23rd May 1986. This act refers to the Stockholm Conference of 1972 and based on the article of the 253 of the Constitution. This act we have already studied, then I am just telling on. The Environment Protection Act 1986 rules lay down procedure for establishing standards of emission and discharge of environmental pollutants. Then Act of 1989, the objective of the hazardous waste management handling. Rules is to manage the emission collection, import, treatment, storage, and handling of the hazardous waste. Hazardous means the poisonous, dangerous. 1989 Act also stating the manufacture, storage, import of hazardous fruits describe the terms and used in this context and set up power to examine once a year the industrial doings associated with harmful chemical and inaccessible storage accommodations. The 1989 also stating the production, consumption, export, import, and storage of unsafe microorganism, genetically caused organism, or cells. Rules were familiarized with the opinion of the defend the environment, the wildlife, and health in association with the application of the genetic factor technology and microorganism. The 1991 Act, the Public Liability Insurance Act, and rules for the amendment of 1992. The 1995 National Environmental Tribunal Act passed enacted to provide compensation for damages to property, persons, and environment arising from any activity involving hazardous or poison, dangerous substance. The 1997 Act establishing the National Environment Appellate Authority Act enacted to entertain appeals related to restrictions of area where classes of industries, etc. Then 1998 recommend the biomedical waste, that is management and handling also. Rules legally binds the healthcare institution to integrate the process of proper handling of hospital waste such as segregation, collection and disposal and treatment of the waste. Then 1999 Act, the environment sitting for industrial project provides elaborated provisions related to the areas needed to avoid for sitting of the industries, precautionary measures to kept in mind for safe selection and also aspects of the environmental protection which must have been incorporated during the execution of the industrial development projects. Then 2000 Act stating municipal solid waste management rules. Municipal authority accountable for the task of collecting, segregating means classifying the different waste and storing, transportation, processing and discharging the municipal waste. 2000 again another act, the ozone depleting substance regulation and control of the ozone depleting product. Rules were enacted to regulate production and consumption of the ozone depleting substance, maybe like CFC producing items. And another laws also there, we can discuss on the further class. Okay, thank you.